Now, moving to this, recent proceedings at the Nkabinde Inquiry, which is investigating the fitness of South Gauteng Director of Public Prosecutions, Andrew Chauke, to hold office, have seen significant testimony from former KwaZulu-Natal DPP, that's Advocate Moipone Noko. Noko's testimony has emerged as a central pillar of Chauke's defense against allegations that he acted unlawfully and outside his jurisdiction regarding the controversial Cato Manor unit. Let's unpack this development with Dr. Suhayfa Bhamjee from the University of KwaZulu-Natal. Dr. Bhamjee, good to have you on the program this evening. So a key issue before the Nkabinde inquiry is whether Andrew Chauke acted unlawfully by operating outside his jurisdiction. Let's speak about this. From a legal standpoint, how do we distinguish between an administrative irregularity, if you will, and conduct that actually rises to illegality?
Evening to you, Nhlanhla, and all the viewers. Thanks again for having me. So that's a great question. I think if we think about it, administrative irregularities can be remedied, if that's a good word to use, provided, of course, that the administrative error is not so major as to result in prejudice to anyone on the receiving end of the process or the procedure or what it is. So an administrative error may be major, it may not be, but in this case, I don't know that we're necessarily looking at administrative error in the sense that Chauke now through Advocate Noko's testimony, it's now becoming a little bit more corroborated that he was appointed by Advocate Jiba. And we see from the National Prosecuting Authorities Act and, well, the Criminal Procedure Act, that the NPA, the National Director of Public Prosecution, can give a DPP from a different jurisdiction, a geographical jurisdiction, the power and the authority to deal with matters in other jurisdictions. And there's very many reasons for that. And that certainly became evident through the testimony of Noko. But the question is, while under that mandate, so that appointment may have been lawful to run with it outside of your geographical jurisdiction. But the question about the ultra vires question, how you carried out that mandate, that may well be another story. But clearly we'll see more and more getting more details about it as the days unfold. But of course, we must wonder if witnesses are going to pitch up, because we saw that again as a significant hurdle for the evidence leaders today.
Dr. Bhamjee, Advocate Moipone Noko has been very clear that she appeared at the inquiry on behalf of Chauke and refused to testify in a way that aligned with the current NPA's position. What does this tell us about internal fractures within the NPA, and how damaging are such public divisions to prosecutorial credibility?
Look, it's extremely telling, because you remember at the last adjournment, when the evidence leaders were listing the witnesses that had pulled out, Noko was one of them. And when she took the stand this week, she was very clear to say that she's here, or she was taking the stand to essentially clear her name, that she is fearful of, because, and I think she spoke in chambers, in chambers with the commission and that sort of thing. The evidence leaders consulted on that. But about, what it is that she's fearful. And even towards the end of that first days of testimony, or even at the very beginning, you could see that she was actually choking up and quite emotional, at one point where the commission had to give her time to recompose herself. But we must say that that alone tells us of the division. Maybe even within the NPA itself, there's this measure of fear, which it was clear to me a reason why she was not willing to give testimony, why she was pulling out. But again, I think she did the right thing. She was actually, when she presented her evidence, she was quite firm, quite clear. There was little, that she was unclear about. And I think Advocate Nkabinde also did a great job, fantastic job, as always, of getting that corroboration through her statements, linking it to all the various other pieces of evidence coming through. And yeah, on the stuff that she's not representing the NPA, I think the commission was also clear is that, you're just here to give us the facts so that we can make a decision. But Noko was quite clear about she's sort of done with that sort of, the organization. And here now she's also just worried about her own integrity and doing the right thing.
So Noko also insists that there was prima facie evidence to prosecute the Cato Manor unit as well as Johan Boysen, citing 23 interconnected dockets and about 28 murder charges. So in law, how strong does a prima facie case then need to be before racketeering legislation can effectively or legitimately be invoked?
Yeah, so the prima facie just means that we've got enough on one side to create the reasonable expectation or belief that a crime has been committed, right? And it doesn't have to weigh extremely heavily in the sense that it's a different criteria if you're looking at a racketeering, or it's a different criteria if you're looking at murder, or if it's a different criteria if you're looking at housebreaking. Prima facie is prima facie. But what you're looking at is certainly when we saw the testimony today also, when Nkabinde was making the list, when you're thinking about and making the links, whose name appears at the top, whose name appears at the top, whose name appears at the top. And then for lay people, even if we're not asking about the prima facie question, we then ask, well, why is that name or those names appearing at the top? And so from the outside, you go with as much solid evidence as you've got. Of course, it depends on what the other side comes in to poke holes and how you recover. But clearly, it certainly appears from the version of events that we've got from Nonko and the way Nkabinde cross-referenced in his examination of her, that I think from the outside looking in, we are looking at, and if you think about what racketeering is about, it's about organized crime. It just means that it was planned and structured, etc. And I think we can see some level of organization in that respect. It's not organized in the sense that how we think about, the mafia movies we watched, about the American mafia and the gangsters and that sort of thing. We've just got to take away from that of organized crime in that sense, and just understand that it's about just strategic planning, and you don't have to have had a gang name or that sort of thing,
Dr. Suhayfa Bhamjee, thank you so much for helping us navigate the legal, institutional and constitutional questions at the heart of the Nkabinde inquiry. Of course, still tracking developments there.